Hello, welcome to DVRO Litigation, Disturbing the Peace and Coercive Control. Today's session is presented by Andrea Castor and Lisa Smith-Szekely. Taylor Brewer will be moderating the Q&A. Before we get started, we want to mention a few logistical notes. In order to turn on live captioning, please press the button with the CC symbol. It's at the bottom of your screen if you're on a computer. This session will be recorded and materials will be uploaded to the LAAC website within 1 week of the event. And you will also receive your MCLE certificates within 1 week of the event by email to your registration email. Please feel free to use the Q&A to ask your questions. Thank you.
All right, Taylor, do you want to take us to the next slide?
Absolutely.
There I am. Okay, so welcome to our presentation. Thank you to Lisa for asking me to do this with her, and you, Taylor. I am, as it says, an attorney in private practice for a long time. Don't want to, long time. Everyone who's here on this presentation, doing it with me and listening to it, who work in the nonprofit field, you are heroes. You are the people that I wanted to be. I began volunteering with legal aid at the domestic violence clinic in Santa Monica Courthouse while I was in law school, and I continued volunteering with the various organizations, but could never quite find a job that would allow me to pay my bills. So my practice is almost entirely family law with guardianships thrown in because there is a large crossover there. And I would say that I hate money issues. I love custody issues. And a good portion of my practice is not only minors counsel work, but also domestic violence. And I also have a background in special education, working with families of children with special needs. So we all wanted to, kind of make this a little lighthearted where we could. And my fun fact about me, as you see on the bottom, is that when I can, I try and throw in or paraphrase movie quotes, particularly Star Wars, in my points and authorities. And my favorite one is from Rogue One up on the screen. I don't know if any of the judges have ever caught it, but I tend to use that one a lot because it's got such a wide thing that it can apply to. So that's me.
There's applause in the chat. So
thank you. Thank you.
Yeah, Andrea. Hi, everyone. My name is Taylor Brewer. Thank you all for joining us today. And thank you to the two presenters for taking the time and sharing your expertise with us. My name is, again, Taylor Brewer. I'm a staff attorney here at the California Women's Law Center, but I broadly oversee the Economics Security Division that we work with and under, and broadly focus on homelessness prevention. I'm a former staff attorney at the Legal Services of Northern California, where I began my legal career and got experience in the broad range of poverty law in general. And my little fun fact today is that I once actually saved a cat from a tree, no fire emergency personnel needed. So that was my little fun fact.
I am obsessed with that fact. I am like a verified cat lady, and I have never saved.
As am I.
All the best people are, I think. Okay, so I'm Lisa Szekely. I'm a staff attorney at the Genesy Center. I've been working in the nonprofit family law space in LA County for almost 10 years now, which is wild. I started at the Harriet Buhey Center back in 2013. And since 2020, I have been a staff attorney at the Genesy Center. I just wanted to briefly kind of highlight some of the Genesy Center services for people who aren't familiar. We are a holistic domestic violence services agency. We're based in South Los Angeles, and the majority of the clients that we serve, as well as the majority of the leadership of Genesy Center, including our Director of Legal Services, Allison Messenger, and our Executive Director, Karen Earl, are Black women. So I always like to highlight that, we try to provide culturally appropriate and competent services to our litigants. And despite my deep whiteness, most of the staff of Genesy are from the community of South Los Angeles, as well as the executive board of directors, leadership. We provide case management services, therapy, support groups, domestic violence classes, emergency shelter, transitional shelter, permanent housing assistance, free legal services, including family law and immigration law. We have a workforce development division. We are the community partner for the LAPD's 77th Domestic Assault Response Team, or DART station. And we run the restraining order clinic at the Inglewood Courthouse. So that's kind of a real broad overview of the stuff that Genesy does. And if you have any clients in the kind of South Los Angeles, Central Los Angeles area, you are welcome to refer them to us. My fun fact is one time I told a judge that there were a plethora of reasons that he should rule for my client, because I forgot how many reasons I'd listed out as I was talking. And then he asked me how many reasons that was, and I had to say more than 3. And then he turned around on the bench and I could tell that he was laughing at me. So that was great.
Always good when you can make the judge break.
All right. So our training today is going to be broken up into 4 basic parts. We're going to spend the majority of our time on the first 2 parts, which are the statutes and the case law. We will also have a good amount of time talking about the pleading preparation, because pleadings, and in particular your declaration, is very important when you're dealing with a case that doesn't involve kind of physical violence. At the end, we'll talk a little bit about courtroom advocacy, but that's going to be a pretty truncated discussion because we have a whole other training on that will be linked later on in the slides. So if you want to have a whole kind of training about courtroom advocacy practices, that is definitely available. So we don't want to kind of repeat, all of that training, but we wanted to bring in some points that are pretty specific to these types of kind of coercive control and disturbing the peace type cases. And then I just wanted to say, we're going to try to save time for question and answer at the end. But if things come up as we're talking, please put them in the chat or in the Q&A. Having these trainings online is great, right? Because so many more people can attend. We don't have, even if you have something else going on that day, you might still be able to pop in for a lunch training. But on the other hand, sometimes it just turns into 4 talking squares and a PowerPoint. So the more interactive that we can make it, the more feedback you guys give us. I love to see the little reaction hearts popping up. It makes it feel a little bit more interactive, even though we're kind of all out in our separate spaces. So feel free to use the chat and the Q&A as much as you would like during this presentation. And next slide. Perfect. So we're going to jump right in and we're going to start with the statutes. So these are the primary statutes that are going to form the basis for restraining orders based on coercive control. We're going to talk about each of them in a bit of detail. You're going to have a copy of the slides. If you haven't already received it, you'll be receiving it at the end of the training. So don't worry if we end up going a little bit fast on the statutes, because you're going to have all these citations and stuff to look back on. All right. So the first statute, the kind of basic statute, Family Code Section 6203, lists the what constitutes abuse. And of course, the earlier provisions of 6203A, like 1 through 3, are causing, attempting to cause, or placing a person in fear of bodily injury and sexual assault. So those are pretty straightforward, right? Not to say that restraining orders based on that kind of conduct are easy to litigate, but it is a bit more straightforward than the focus of our conversation today, which is restraining orders based on non-physical abusive conduct, including disturbing the peace and coercive control. So we're going to focus on the portion of the statutes that specifically relate to that type of abuse. But I did just want to highlight something that I cite at the beginning of almost all of my points and authorities in cases like this is section 6203B. So even though you have all of the language of 6203A4, which says that there's a whole host of behaviors that can be enjoined, and that list includes many non-physical, acts of non-physical abuse, they still, in the 6203 statute, specifically put in there that a finding of abuse is not limited to the actual infliction of physical injury. And I just think that's really important. And I think it's in the statute so specifically because of how common it is to have, the issue of judges refusing to grant protective orders when the allegations aren't physical abuse. And I would love to say that the creation of new statutes by the legislature and the policy advocacy work that the whole community has done around the issue of coercive control has really changed the kind of day-to-day impact in the courtrooms. But I think as we'll talk about a little more, in practice, we really haven't seen that. So it is still really important to raise this to the judges to be like, you do not have to find this. It is reversible error if you think that you have to find this.
And Lisa, if I could just follow up on that, I think it's important to just keep in the back of our minds as we are in front of new judge. As we all know, we have new judges coming to the family law bench who have probably never stepped foot in a family law department. And for someone who has no exposure in their life, we're all human. We all have our own histories and biases and backgrounds that we come to work with. And for someone who has no experience whatsoever with the idea of domestic violence, it's much easier to wrap your head around physical domestic violence. When you see pictures of bruises, of injuries, when you have a hospital report. But when you are trying to explain, financial abuse and not having access to money and things like that, it's a lot harder concept. So I think, especially, Lisa, I agree, point that out, especially with our newer judicial officers.
All right, let's move on. Andrea, I think this one is you. Andrea, I believe you got muted somehow.
I think I did it myself, sorry. Family Code 60A is the one that is referred to in 6203, and with all those additional areas that the court can use as a basis for molesting, striking, stalking, threatening, sexually assaulting, battering, credibly impersonating, falsely impersonating, harassing, telephoning, destroying personal property, contact directly or indirectly by mail or otherwise. And I hope that one day they add in there specifically electronic means. Coming within a specified distance of or disturbing the peace of the other party. And that's, kind of a mishmash. Some of those are physical, some of those are not physical. But this was the code section that we were operating under, and the cases that interpreted this code provision for many years until the amendment from SB 374, which went into effect on January 1st of 2020. And it really expanded this definition to add in the disturbing the peace. Obviously, that doesn't mean that coercive control wasn't happening before 2022. Until that point, we had to characterize the behaviors and actions that we think of as coercive control as disturbing the peace, because that was what was in the code section. So that was the key word that the judicial officers were looking for. And sometimes it worked and sometimes it didn't. But then we expanded. Next slide. I think this is you.
So let's talk about the expansion. So that's a big old hunk of text. And honestly, it's just copied and pasted from the statute itself. This is the language of the statute. And I'm not going to read it out to you because I assume everybody can read. The highlights are that disturbing the peace is a totality of the circumstances test. And it includes coercive control, which has been defined as a pattern of behavior in effect or purpose that unreasonably interferes with a person's free will or liberty. And the basic hallmarks of coercive control are isolation, financial control, controlling and monitoring movements and communication, using someone's immigration status against them, and engaging in reproductive coercion. And I think that's, pretty straightforward, right? Those are some pretty concrete examples. And these sections, items 1 through 5, serve as great subheadings in a declaration. Section 1, isolation, and then describe all the ways in which your client was isolated by the other party. The only one that I wanted to kind of flag for you guys is number 4, using someone's immigration status against them. And I just wanted to bring in Evidence Code section 351.3, which is the provision of the code that says that, a party can voluntarily disclose their immigration status to the court. But the other party can't put on evidence about the other's immigration status without asking for an in-camera hearing and the judge deciding whether or not it's appropriate. And I bring that up because, we do, I'm sure you guys do. You can give me kind of like a yes or no in the comments, but, in LA County, at least, we have a lot of clients who have immigration statuses that make them more vulnerable. And it has become, in my experience, a very, very common defense of abusers to say the only reason there's a police report, the only reason she's doing this DVRO is because she wants immigration status through a VAWA or a U visa application. And so sometimes if I know that attack is coming and there's maybe something in the history that would, that an opposing party could use to kind of further this case and cast doubt on the credibility of my client, sometimes I make the strategic decision to not include the immigration status portion, and then I use Evidence Code section 351.3 to stop the opposing party from attempting to bring this up in court. I've definitely gone the other way and included, information about immigration status. But I think it's like everything in family law, it's a strategic and fact-based decision, but just know that you do have the option if you think the other party may have some kind of compelling way to argue about, a motive outside of fear that a litigant is pursuing a DVRO. You do always have Evidence Code 351.3 to fall back on to keep that discussion out of the court proceedings if you feel that that's going to kind of muddy the waters in a way that won't be beneficial to your client. All right, and I think we can move along to the next slide.
There is
and Lisa,
sorry, just from the chat, there is one question there, and let me know if we go into this later, but can coercive control be a sufficient crime to support a U visa? I thought no, but happily to learn differently.
So U visas are, and I'm not an immigration attorney, so grain of salt, I'm sure my colleague Lizzie, who is our Genesee's immigration attorney, will be like, oh my God, Lisa's talking about a U visa. But my understanding of U visas are that you essentially like are the victim of a crime that is reported, and then you cooperate with a law enforcement agency. And it's my understanding that there is some section of the penal code that could address coercive control. And so if a report was made and a victim cooperated with the police, you know, and their abuser was like charged under that code section, then perhaps it could. But again, not an immigration attorney.
Thank you.
And before we go on to 6309, I just want to say, going back to 6320C, Lisa and I have both observed and talked about this a little, but it's felt like since the passage of the amendment adding coercive control to the family code, a high number of judicial officers seem to feel like the legislature has now gone too far, and they're really more reticent than they were before to apply the language of the statute as written to the cases before them. I've seen the backlash in transcripts and in discussion on the various listservs that I'm on, and it's as if judges and attorneys have not fully bought into this idea, and or they have bought into the idea that it's just too easy now to get a restraining order, and that women in particular, without getting into gender issues, abuse the ease and availability of restraining orders and use them to gain litigation advantages. And that is just so inconsistent with the reality that those of us doing this work see every day. It's very frustrating to us, but I think it means that our role to advocate for our survivors is more important than ever. And hopefully the information in this training is going to help to help you prepare to address this backlash. So with that said, moving on to the newest DVR, the newest code section under the DVPA, 6309. So before this year, there was really no consensus between judicial officers, at least here in Los Angeles County, as to whether or not discovery as per the Civil Discovery Act was permitted under the DVPA. It wasn't expressly prohibited, but if you think about it, how do you do written discovery in 30 days when DV matters have to be set within 21 to 25 days? And before this year, I never heard a judicial officer say that serving written discovery was good cause to continue and reissue a TRO. I'm sure I don't need to get into the logistical nightmare that doing a deposition on a DV matter can be, even if you can ensure that it won't further traumatize your client. So along comes SB 741, effective January 1st of 24, that expressly allows the court to grant an oral or written request to perform discovery in DVPA matters with a finding of, as long as it makes a finding of good cause. And 6309D sets forth what the court has to consider in making this good cause determination. And so in the interest of time, I'm not going to go through the 6 factors there, but it does list it out, and there is a catch-all provision. But what's really compelling about 6309, and the real reason, in my opinion, that you should read it, is subsection A, the legislature's findings in enacting this statute, which are essentially set forth right here in the slide. Have talked about this too, and we agree that it would be better if the public policy language had been separated out from the rest of the statute, and so that it was just kind of hanging out there as part of the DPA and not connected specifically to. But we have to take what we can get, and it's better than nothing. And so in this language, it's interesting to note the phrase litigation abuse. Whether or not litigation abuse is not mentioned in 6320 or 6203. But as we all know, litigation, the court is often weaponized against our the other side. And if whether or not this language will result in the courts now starting to recognize that expressly, how easily and often with impunity abusers weaponize the legal system, or if we're just still stuck and left to the mercy of the vexatious litigant. It's yet to this gone up on appeal yet, so we don't have. I'm seeing that my audio is going out, so I'm just going to take my. Is that better? Okay. So I don't know if we're going to be left to the vexatious litigant statutes, but again, it's a start. And it's interesting to note that in Washington state, litigation abuse, that's the one state that I know of where litigation abuse is expressly an acknowledged form of domestic violence. Next slide.
Oh, and I just wanted to ooh, got an echo. For Tawny Minna, it's 6309C. That is the citation. Domestic violence. It's judicial officers and court evaluators often misunderstand or overlook litigation abuse and its effects on survivors. That is in the that's in the findings of the statute. Okay, so now we're going to jump into case law. Like I said, don't worry about the citations and all of that because you're going to have it with you. So as you can see from kind of this timeline here, we're working in a fairly known universe of cases. Like if you wanted to, you could actually read all of the cases about coercive control and be ready to go into court with every published opinion about coercive control that exists because it's a pretty limited universe. We have one case beginning in 2009, and then all the rest of the cases are from 2014 on forward. And I just wanted to kind of flag that because what happened in 2012 is that two UC Berkeley law students founded the Family Violence Appellate Project. And the Family Violence Appellate Project has been responsible for the vast majority of these decisions, whether it is getting, like litigating it or finding private practice firms to take it on pro bono, or just getting it published so that there's things that we can use, right? Because one of the issues with a lot of kind of domestic violence cases that make it up to the appellate court and family law cases in general is that they're just not published. So then you can have a case that kind of matches your facts perfectly and you cannot rely on it in appoints and authorities because it's not published. So the work that the Family Violence Appellate Project has done in creating this universe of cases, getting them published so that we can put them in points and authorities, analogize the conduct of the litigants in our cases to the conduct of litigants that have already, been decided by the Court of Appeals. It's just incredibly invaluable. And what I tend to do with cases, to the extent possible, and we'll talk a little bit more about this in the pleadings, but I, look for cases that have facts that are like mine or not quite as bad as mine. And then I analogize my facts in appoints and authorities, where I cite the case, I describe their conduct, and then I say, the conduct in my case is not only similar, it's more egregious. So if it was reversible error not to find for this litigant, then it would really be reversible error not to find for me. And so I think that's one kind of very effective way of getting the facts of these cases and the gist of these cases and the policy language that exists in these cases in front of judicial officers, particularly new ones. Okay, we can go to the next slide. And some of these will be pretty quick, but I just wanted to briefly address my GIF usage. So Andrea and Taylor and the California Women's Law Center and LAAC are not responsible for the GIFs in the presentation. That's me. I'm like a GIF queen. And I just wanted to say, you know, they're not meant to be offensive or disrespectful. I don't mean to make light of domestic violence. It's just a very heavy topic. And sometimes I think it would be helpful to have a little bit of levity while we talk about these very difficult things. So please don't take them as me making fun of any of the litigants in these cases, because for the most part, it is not.
And I wish I could take credit for some of them. I appreciate them.
Okay, so Nag Carney is essentially the first case that's really talking about, you know, non-physical domestic violence, the conduct in the case. You know, this was a case, it was a dissolution of marriage. They'd been married for quite a while, and they were involved in a pretty heated custody case, according to at least the way the Court of Appeals described them. And over the course of the case, the opposing party had essentially accessed the victim's emails and then attached the emails that he had obtained without her authorization to pleadings, and then said in court, I have more from my unauthorized access of these email accounts, and the only thing I plan on doing with them is attaching them to more court pleadings. So you shouldn't issue a DVRO for that. And so the trial court agreed. The trial court did not issue a restraining order and said accessing somebody's emails and then threatening to make them public isn't domestic violence. And the appellate court held that it was. One notable thing is that there was a history of physical abuse in this case. So there's kind of these, references to a very old conviction for domestic violence. So this was not a kind of like pure no violence case, but the conduct that led to the restraining order was primarily the nonviolent conduct. And we can move along. Andrea, you're muted still.
Sorry, I have to turn it off because, as you heard, my phone rings and I can't separate it out. So the next big decision that we have, and we're kind of going in chronological order, is Burkett versus Brumbaugh, I believe, is how you pronounce it, which really solidified the definition of disturbing the peace of the other party. This case was a request for a DVRO between parties who had dated and thankfully did not have any children in common. The victim had terminated her relationship with the abuser, and he was not willing to accept that. So he kept contacting her despite her many, many requests that he stop. His communications contained sexual innuendos. He would turn up unannounced and uninvited outside of her residence at all hours. He knocked on the door sometimes, but the victim would not let him in and asked him to leave. And when she asked him to leave, he would get angry, continue yelling and pacing outside, and then finally give up after about 10 minutes. And in this case, the court, as I said, solidified the definition of disturbing the peace of the other party as being conduct that destroys the mental or emotional calm. And the court applied the same reasoning essentially as Nag Carney and affirmed the issuance of the protector. Next slide.
Right, so this one I'm just apologizing in advance because I don't know how to pronounce the names, and I've been told several times, and it's like it just evaporated from my brain. I don't know, but I'm gonna go with Gao v. Zhao, and I'm gonna call it Zhao. So this is a case where a denial of a protective order was overturned by the Court of Appeals. And the conduct in this case was that the mother witnessed the father physically abusing the child, once on video, once in person, where the father was choking the child, and once viewing surveillance footage outside of a testing site where the father was assaulting the child after he took a exam. And the court found that the mother was not a victim of domestic violence because witnessing your child be abused doesn't make you a victim. And the appellate court overturned that decision and said, no, if you witness abuse against your child, that would kind of disturb a reasonable person's peace. And it did, in fact, disturb this woman's peace to watch her child be choked by their father. So even if the only physical conduct that is happening is between the, one party and a child, the other parent can file for a protective order. And I know some of you guys may have experienced this. We certainly experience it in LA County in various courtrooms, is that the judges will say, no, mother needs to, the paperwork needs to be filed with mother acting as guardian ad litem and the child being the victim. And there may be times where that's appropriate. Maybe if the mother has never witnessed it and it's only based on the child's statements, then maybe that is appropriate. But if the mother has witnessed abuse for sure under Zhao, she has the right to file. And judges should not be stopping you from filing or refusing to hear these cases because the mother does not want to file guardian ad litem. But that is, I just want to flag for everybody that that's something that does happen, and we don't have a good solution for how to get judges to stop requiring that. And next slide. All right, so I think this one is also me. Sabato v. Brooks. So in Sabato v. Brooks, the parties were married. They completely finished a divorce case in 2012. And shortly after the divorce finished, something happened with the opposing party, and he began texting things like, nothing will separate us. He was telling his roommates, everything is going to be, we're going to be back together and we're going to be together forever. And then he purchased some ammunition for a gun that he had never purchased, that he hadn't purchased ammunition for in many years. So that was concerning. And the victim filed for the protective order. And it was held that, even if the contact between the parties is not threatening, even if there's no suggestion of violence, even if it's just, I love you and we're going to be together forever. If it's unwanted and harassing, then that can warrant the issuance of a protective order. And the frequency of these texts, according to what the appellate court found, was that they were about once a week. So she was getting weekly texts. So I think this is a great case. If your client is getting 10 texts a day or 10 texts a week, say, well, in this case, the litigant here was only receiving 1 text a week, and the court found that because it was harassing and unwanted, that could form the basis for a DVRO. So these are 10 unwanted texts a week. So if it was, if that justifies issuing a protective order, then the 10 texts definitely justify. And next slide.
Okay, Rodriguez versus Menivov. Hope I'm pronouncing that correct. In this case, the parties were in
what I would consider an unstable and toxic dating relationship that already had a history of violence before Miss Rodriguez became pregnant with the party's child. She resumed the relationship because of the pregnancy, which, as we all have probably experienced, I know I have, often happens. And the respondent engaged in the conduct that's listed above, calling multiple times, etc., enrolling in her 3 of her 4 classes, and other things, isolation, things like that, in addition to the continued threats of and actual physical violence. And the trial court denied the restraining order. But under Nadkarni, Burkett, and Evilsizer, and Sweeney, the Court of Appeal disagreed about the mental abuse with the totality of the circumstances test, and also said that because there hadn't been an act, the remoteness in time that the trial court pointed out was not a reason to deny it. And given that the second sentence of the appellate decision is, although the trial court found substantial evidence of physical violence, it concluded that it was too remote in time and not sufficiently likely to be repeating. So I guess the silver lining is that we ended up with this case law. Next slide.
All right, so this is the fantastically named Evilsizer v. Sweeney. Unfortunately, Evilsizer is the victim in the case, and Sweeney is the perpetrator, which it would have been nice if the names were reversed, but it's fine. So in the basic gist of this case is that obtaining private information about someone and disseminating it when they ask you not to is going to be abuse. And you don't have a right to do that under the First Amendment. And there are judicial officers who are very understandably protective of the First Amendment, and they don't want to issue rulings that will negatively impede people's First Amendment rights to speak. But as we'll talk about in several of the kind of upcoming cases, the First Amendment does not actually kind of give you the right to make another person's life measurably worse and humiliating and traumatizing. So, you know, in this case, this is actually fairly egregious, and it's you know, the opposing party downloaded tens of thousands of text messages from the victim's phone without her knowledge. He got texts from her attorney, from her parents, texts about medical issues. He downloaded the Notes app, which the victim was using as her diary. He accessed her Facebook account, changed her password, and routed all of her Facebook communication that she received to his email. He attached the text messages to his pleadings and threatened to reveal more of them as leverage in the divorce proceedings. And so the court found, yes, that constitutes abuse.
And I think that case is a good lead-in to Altafulla versus Irvin. This case just makes me cringe. I believe he was a live-in boyfriend. Maybe they were married, but prior to the instant case, Irvin was married to a woman who got a protective order, a restraining order against him and their children in 2011. He denied the conduct in that and then used the legal system to sue her based on her allegations of the threat. And in that action, he actually conceded that he made what he called an unfortunate and irresponsible statement to his former wife. And then fast forward, he explains to the petitioner's 17 and 9-year-old daughters, and this is where it got really cringy for me. He described oral sex to her daughters and told her daughters that he thought that their mother was sleeping around, and that they could potentially get STDs from her. So as for it, with respect to that conduct, in addition to it being designed not just to embarrass Altafula, I always have a little bit of a hard time saying that. The court noted there was an unmistakable manifestation of his extreme anger towards her. And it doesn't matter for these purposes, but this case also goes into Irvin's First and Second Amendment challenges to the trial court's decision. So if that becomes an issue in one of your cases, you may want to look at this case for that also. Next slide.
So McCord v. Smith is another very useful case. And it highlights kind of a different trend that I wanted to point out for everybody, which will be the case in several of the cases, is that this is actually a situation where both parties filed for domestic violence requests against each other. And in this case, the abuser filed first. And, we talked a little bit about litigation abuse and the weaponization of the court system. And this is I think, an excellent example of that. I find it to be somewhat common, a somewhat common tactic of abusive people who are inclined to use the court system to further their abusive conduct, is that to file preemptive or retaliatory domestic violence restraining orders, leading to both restraining orders being heard in a single proceeding, and in the hopes that the court will essentially deny both of them on the basis that both people were acting poorly. And it's a strategy that is somewhat effective, frankly, without kind of attorney intervention, in my experience. And I think the mutual dueling DVRO situation may be the topic of a future training with LAAC, because it's a trend. So in any case, the facts in McCord v. Smith are visiting the victim, texting, emailing, sending her photos. And the photos in this case were pretty notable. He sent a photo of her nursing license that he had possession of somehow and asked, "Is this you?" And then followed that up with a photo of her naked. And the court kind of understood that text message conversation to be, "I am going to do something that is going to affect your nursing license and your ability to kind of support yourself." And that by itself, even though they were, these unconnected seemingly incidents were part of an overall pattern. All right, so we can move along.
Oh, Jan F versus Natalie F. Full disclosure, I was the trial attorney in this case. And on the slide, it says Ross is the worst, right? And my initial reaction to that was, no, Jan is the worst. This case, and just curious if you want to throw it in the chat, I wonder how many of you have read it. I think that in this case, which was originally unpublished, but was later certified for publication. In this case, the Jan, who was the petitioner in the underlying paternity action, weaponized the local law enforcement agency by calling in repeated unwarranted welfare checks to mom about mom, claiming he didn't know where she was, claiming that she was, going to be going out of the state, and that would violate the ATROs, and she may be abusing the kids. And, I will keep my opinions on how helpful or not the law enforcement can be. And no disrespect to the good ones out there. If you're on this training, you are one of the better ones. But they had no problem, they would come out and just say, we know this is another call, but we have to do it. And it was concerning because mom did have a confidential address, and through those welfare checks, dad was trying to get her address. Not only the welfare checks, that was really the basis for the appellate court's decision, was these repeated uses of the welfare checks. But the appellate court did not get into the literally hundreds of emails and Our Family Wizard messages in a very short amount of time that father was sending. And it was, if you know, for me personally, this is one of those cases that we get tired of. So if you are doing these cases and you get tired, these are hard cases on us, even though we're objective parties. But going back to the ruling on this, when we had the hearing, the trial court said essentially, counsel, is this all you have? And my thought was, what else do I need, Your Honor? What more do you want? But trial court was very hesitant to issue a restraining order based on welfare checks, not wanting to put a prior restraint on anyone's right to call in welfare checks. But what the reason it was a problem is because the trial court did not even hold a hearing, an evidentiary hearing, to determine if those welfare checks were made in good faith. And that's why it was very nice. That's why I was able to breathe a little when they certified this for publication. And it really became obvious that it was error for the court to say, I don't even think this constitutes a restraining order, but it didn't have. So, yeah, if your judge ever says to the other side, you don't need to, the other side starts talking and the judge goes, I'm helping you, basically says, I'm helping you. You don't need to talk. You're winning right now, which is what she said to him in pro per. That's when, in my mind during the hearing, I thought, when we're done with this, I'm calling FBAP, and we did. So, so that was the Jan F and Natalie F case. And if anyone has any questions about that they want to ask me later, I'm happy to go through it with them. Next slide.
All right, so I used a Leonardo DiCaprio gif, and I'm sorry for Leonardo DiCaprio stans, but he does date much younger women, and that was the facts in this case as well. The big takeaway in this case, and we won't get into all the facts in the interest of time, is that the finding that the court has to make is not an objective standard. It's not a reasonable person standard, whether a reasonable person's peace would be disturbed. It's whether or not this person's peace was disturbed. I also just want to give a big shout out to Judge Uhas, who was the judicial officer in this case, who ordered opposing party to change. He took out a $4 million life insurance policy on the victim with himself as the beneficiary. And Judge Uhas made him change the beneficiary to a charity of the victim's choice, and then ordered the abuser to pay $200,000 in attorney's fees. So incredible. Okay, moving right along.
Hatley versus Southard, which is, I think, the most recent case we have on coercive control. The Court of Appeal, it's a great case to read, if for no other reason than the Court of Appeal's attitude towards the Riverside the judicial officer who did the trial court, was at the trial court. The conduct included the opposing party threatening to kill himself, which, as we probably have all seen, manipulation, requiring the victim to get authorization to make minor purchases like Starbucks, financial abuse, restricting access to ATM cards, characterizing her earnings as his money, not their money, and frightened her into thinking she could get into legal trouble for using it, and threatening to disconnect her cell phone service, and took her car. The judge had the victim testify and then denied the restraining order. without making any inquiry of the opposing party and stating that the victim's testimony alone did not establish abuse. Whereas I think if he had the opposing party testify, it might have been different. So this was reversed and the judge was directed to hold a full hearing. Next slide.
All right, in the interest of time, we're going to skip this. So let's just power through.
Lisa, just really quickly, since we are skipping it, I just want to point out number 4, the postings from the excerpts on Facebook. The 2 cases that you may want to look at, which are not in our materials because they don't quite fit in, are the Molinaro case and the Curcio, I think is how you pronounce it, versus Pels. Molinaro is a 2019 case and the other one is a 2020 case. So if you have social media postings, just look at those.
All right. So we're going to talk very briefly about pleadings. Yes, Tony, I think we can put those, I think Andrea can put those cases in the chat.
Yes.
So the very basic overview of the pleadings are that, the declaration and your supporting documents are going to be extremely, extremely important, particularly if you're dealing with a case where you're looking at 10 years, 20 years of abuse, characterized by kind of verbal abuse, restriction of access to funds, control over what people wear. You can see in the sample materials that were sent out, we have a sample application where we break down the type of abuse in each section, and then, give kind of small descriptions of a large number of types of abuse. And in another, we have a kind of a sample supplemental declaration. And I just wanted to include the sample supplemental declaration for you guys because of how many of these cases come to us, which is that, clients or litigants go in pro per to a clinic, they file paperwork, there's a bare bones declaration, if any. It may just be kind of written into the judicial counsel form, the DV-100 form. And it may include only the most recent, why am I here today kind of information. And these cases are harder cases and there are long histories. And so I find it helpful, when I get those cases where the client comes to me after they have filed and there's a hearing on calendar, or they've gone to the first hearing, opposing parties showed up with a lawyer and got a continuance, and then they come to me. I find that going through their history in great detail, preparing a supplemental declaration and filing that is hugely beneficial prior to the hearing to help give the judicial officer a picture of what this relationship really looked like that goes beyond the kind of bare bones information that was in the DV-100. The other important part about declarations are that disturbing the peace is about how your client felt. So it's very easy to kind of focus on putting the facts in. OP did this, and then he did this. But you always have to remember step 3, which is, and it made me feel like, and you include the ways in which the abuse has affected your client. Because that's the key. It's whether or not her peace was actually disturbed. All right, next slide. Can we go for a few more minutes, or do people need to get off right now?
We can't, I think the supporting declaration, if you have exhibits, let's just make sure you put what you can into that, and all of those and whatever else you could think of. So let's go. I just want to touch on, if you could move to the next one. Where is it? Is that the one with our, I don't know why my window's not changing. So the the memorandum of points and authorities and the request for judicial notice. Lisa, you want to just throw that out really quick?
Yes. Okay, so there isn't a sample memorandum of points and authorities because I didn't have a good one that incorporated all the cases. But a memorandum of points and authorities is incredibly helpful. The way that I like to do it is I start with the case, right? Like the case that has the facts that look like my facts. And then I do a paragraph about that case and the holding and what the error was and what the standard is. And then I put in my facts and make analogies between my facts to the facts of the case. So that analogy part will include your facts that are somewhat similar to the declaration, right? But you want every fact that you reference in your points and authorities needs to be in the declaration, right? That's how it becomes testimony, is by, if it's just in a points and authorities, it's not testimony. If it's in the declaration, it's testimony, and now you're making an argument based on testimony. So I do my declarations first, my points and authorities second, to make sure that every fact that needs to be in the points and authorities is in the declaration, so that there's kind of like evidentiary support for what is being pled in my points and authorities.
And then going to the request for judicial notice, similar to the great thing about the request for judicial notice, and I've heard judges say they think they're underutilized in restraining order hearings, is that the court has to take mandatory judicial notice of certain things and permissible judicial notice. So you are supporting your case and not letting the court off the hook in considering it. So use judicial notice effectively with relevant case law. If you've got criminal records, prior restraining orders, whether from California or elsewhere. And I usually end up doing the request for judicial notice. One case that I use a lot and do a request for judicial notices is if the one case, I forget the name of it off the top of my head, but where the person has violated the TRO. There's that case that says that the violation is no matter how much, then it's the basis for the issuance. Yes, thank you, Minty.
There's no such thing as a de minimis violation.
No such thing as de minimis violation. So I usually do, especially if I have a newer judicial officer, I'll do a P&A, but I will follow it up if the client, if I need to, or I feel it's appropriate, and I think the judge may not get it, with the request for judicial notice. Next slide.
All right, so we'll talk briefly about courtroom advocacy. Now, there is that whole other training that's linked later in the slides. So don't worry, you can do a whole full hour and a half of me and Carrie Holmes from SDV LP talking about courtroom advocacy, if that's something that interests you. But I just wanted to go briefly over the basic rules. So before you go into court, you should have a testimonial outline. It's not a great idea to go into, in my opinion, and I'm an over-preparer, so I understand that, but I don't enjoy going into court without a testimonial outline. And the way that I structure my testimonial outline, meaning what questions I'm going to ask my client and the other party and any third-party witness, is structured around both a timeline and also what pieces of evidence I have to introduce. So I will have a section that's like Exhibit 1, and I make sure to include in my testimonial outline all of these 4 steps, because if you miss one of them, it can make getting your evidence actually entered into evidence more difficult. It can kind of unnecessarily make you look like you're not the most competent attorney. And the way that I remember it is meow. So I have a helpful cat. It's not my cat, but it looks a lot like my cat, who I don't know if you can hear, but is actively meowing outside my door right now. He's really mad that it's closed. So step one is that you mark your evidence, right? So every exhibit, I know what order they're going to be introduced in because I have it in my testimonial outline. So I pre-mark each exhibit, pre-marked as petitioner's exhibit 1, 2, 3. Then when it comes time to ask my client about that exhibit, I hold it up and I say, I'm holding what's been pre-marked as petitioner's exhibit 1. It is identified for the record as a 1-page color screenshot. And then I hand it to opposing party and the bailiff. That is the easiest part. So just make sure you do that and say that, and then you're fine. The tricky part is the authentication of a document. And the authentication of a document means you are showing the court that this thing is what you say it is and that it shows what you claim that it shows. So you ask a series of questions to your client to authenticate the document. So in the instance of a screenshot of an Instagram story, I would say, what is this? And my client knows to say, because I've talked about it with her in advance, to say, this is a screenshot of Dad's Instagram post about me being a big hoe. And I'm like, how do you know that it's Dad's Instagram post? Well, that little circle on the top is their profile icon, and that is a picture of him. Does anyone else routinely have access to his Instagram and post stories on his behalf? No, throughout our relationship, he was the only one who posted stories on his own Instagram. When did you take this screenshot? I took it on blah, blah date. Did you edit this screenshot in any way? No, I didn't edit it. Is this screenshot a true and accurate representation of the story that you saw on Instagram on blah date? Yes. And then at that point, you've authenticated your exhibit, right? You've given it a date, you've given it a time, you have said how your client knows what it is and where she got it from. And then the last step, which is a step you do have to actively do, and you haven't finished if you don't do it, is then after they answer that last question, you say, I move to offer this exhibit 1. I moved to offer petitioner's exhibit 1 into evidence. And if you don't say that, and you just roll along into exhibit 2, then you haven't offered it into evidence, and then it's not in evidence. And sometimes your judicial officer will remind you if you forget to do that, and sometimes they will not. So you should make a note or something on your hand or think about this cat and always offer at the end.
Absolutely. Next slide, please. So I'm going to go through this kind of quickly. Examining or taking testimony from your client. I don't know about you, but I have found that domestic violence victims and survivors don't always make the best witnesses. Some that may be shocking to some of you. So you need to gauge that and practice and prepare them. Practice refreshing recollection, teach them to speak slowly, not interrupt the judge or the other party, and basic courtroom etiquette, which can be very difficult, particularly if the other side is not engaging in the same courtroom etiquette. And so it's okay to tell your client to as they're on the stand, if they need to listen to the question, take a beat, and then answer. I talk a lot with my clients about what to do if it's a yes, no question and they want to do one of those yes, but or no, but. And all they have to do is look at me and kind of give me a look, and I will know, because I'm going to be able to come back on redirect. So I want them to know that they will have their opportunity to add in that but, what comes after that but, and let them know that it's okay to show emotion. They do not need to be stoic on the stand and hold it all in. And I've seen that backfire when they do, because judges think, well, this hasn't impacted them. They're not bothered by it. And make sure that your client knows what incidences you are going to ask about and has a general sense of the timeline. So your questions should be simple, targeted, and then, as Lisa talked about the evidence, make a plan on what question to ask in order to discuss that evidence. Like, a picture of a bruise or something like that. And don't forget to ask your client about the impact and how this affected them, how they could see it may have affected the children, how they felt, because we have to know how it disturbed the peace. And then just be sure to prepare them for the process of objections and then cross-examination. So in the interest of time, we'll move forward.
And I just wanted to say one piece about cross-examination that I have found to be the most kind of effective way in keeping my clients' answers on point, which is to tell them that I have a right to object to the opposing party's question. And so I need her to take a deep breath and count to 2 at least, so that I, if it is an objectionable question, can get my objection out. And so first of all, that means that your client won't be answering a question that was improper. And second, it also kind of forces your client to take a breath and not respond with their first impulse, which is not always the best impulse for presenting their case. Okay, so examining the other party, you can call the other party, or you can just rest your case and let the other party put his case on. I tend to just let the other side put their case on. And frankly, if you let them monologue, many of them will tell on themselves. The kinds of things that I've had people tell on themselves: of course, I didn't give her a key to my house. Why would I give her a key to my house? It's my house, and I don't trust her. All right, well, that was an easy restraining order, right? So you kind of let them monologue. You can object to many things that they say, but you don't necessarily have to. So, and you need to prepare your client for the fact that you might not, right? Because if the opposing party gets on the stand and starts saying things like, she's a liar and she's irresponsible and she's bad with money, and that's why I kept everything in my name, and if I let her just do whatever she wanted, then we would be broke because she would have bought a bunch of dumb stuff from Target and blah, blah, blah. And it's not nice to hear things like that about yourself. But the fact that the other party is saying this in court in front of a judge is, I think, more beneficial to our case. So I'm going to let him just talk. And the only time that I won't is if it seems like an objection will throw him off. And then occasionally I will interject an objection to something that's actually objectionable. But I tend to use objections to opposing parties' testimony sparingly, because I think that generally speaking, they tell on themselves, and objecting to things like forms of questions and things like that. Like, I think judicial officers know what is admissible and inadmissible, and judicial officers know what's relevant and irrelevant. And weighing down and taking up a huge amount of time with evidentiary objections when the court probably wants to get through this case as quickly as possible is often not the right strategic move.
And I think also just consider in the beginning, before you get to court, would it be to your benefit and helping the case to call the other side under 776 first before you call your client? Sometimes it's not good in every case. So that's a decision that you have to make.
And we can move on to the next slide. And this kind of goes into what I was talking about with in the previous slide, which is that you need to prepare your client for what the other side is going to say about them, right? They have probably heard it before. It's been put in text messages. They may have been hearing it for the last decade, but it still sucks to hear it in a courtroom. It's embarrassing. There's other people in the courtroom, and opposing parties will talk about sex stuff. They'll talk very disparagingly about any mistake that your client has ever made. And it's really important to have a plan with your client before you go in. First of all, you need to let them know that you might not object, because what the other side will be more damaging to them than to your client. But your client needs to know, in order to maintain that trust that you have, that you're not just abandoning them and letting opposing parties say whatever he wants. Your client needs to know that it's part of a strategy before you're there in the courtroom. You also need to help your client if they are a reactor, right? Some clients are very stoic, and some have big reactions because they have big emotions, and that's understandable. So, I often bring worry stones or stress balls. I hand them to my clients, and I have them kind of under the table, rubbing the worry stone or squeezing the stress ball. I also always keep a blank piece of paper in between myself and the client. I bring 2 pens so that the client can scribble notes about what the other party is saying to me. Even if I don't need the notes, even if the notes are just like, he's a liar, the fact that she has somewhere to get out that anger that he is lying, 3 exclamation points underlined twice, means that it's out on the paper and it's not out on her face or out of her mouth in front of the judge. So those are 2 good ways to kind of manage the feelings that your client will have, and understandably so, when the opposing party says horrible things about them.
Because it will happen.
It will happen.
Laying record on appeal, I think in the interest of time, we'll skip this and the lessons, but this really is its own training through FVAP, and the citation to the FVAP training is in the materials, and I believe it's free. So that's something you definitely want to look at if you think that before you may end up having to bring it up on appeal.
All right, does anybody have any questions? Oh, Eileen, hi. Eileen was one of my interns at Harriet Pugh High.
There's one question still in the chat. Can we completely authenticate and offer evidence into the record through a pro pers declaration?
I think I may not understand the question.
Okay.
Do you know if any case justifies a stay on proceedings? I know that there is specifically a case that does not. So I had a case where the renewal of a protective order, it was time for the hearing on the renewal, but the opposing party was still appealing the initial issuance. And there is specifically a case that says that no, orders can be modified, renewed, etc., even when the underlying order is up on appeal. And if you give me 1 second, I should have it right here. In re Marriage of Carlisle. I don't have the citation in front of me, but it's in re Marriage of Carlisle. It's a 2021 case, and it says no, these proceedings are not stayed while this is on appeal.
Any other questions? I'm sorry, Tani, I don't know the answer to your question, and I'm sure it's very frustrating that the trial court is continuing to make orders during unnoticed hearings, and which is causing you to file continuous appeals. So that is, if there is something and I think of it, I will certainly let you know, but off the top of my head, I do not.
And if you ever need technical assistance, you are welcome to reach out. I would be happy to kind of like review a court summary and give you any assistance that I can. Again, not an appellate expert. There are certain types of orders that are automatically stayed, right? There's like, but it really depends. So it's like, there's some custody orders that the statute automatically stays. There's things about moveaways Like they don't go into effect until a certain number of days to give sides a chance to deal with issues. So without knowing more about your case, Tawny, I don't know that we can give any more feedback.
Well, and Tawny just posted the Q&A, some of those sections like CCP 916 and 917. So those are worth looking at. But we're on limited time. So I think the second one, 917.1 to 917.9, may or may not. So that would be where I would start at least. And
I see oh, go ahead, Andrea. I'm sorry.
Oh, I'm sorry. I was just saying that I too, my email is not listed in the question and answer in this last page, but it was put in the chat, and I'm happy to provide any, if you ever need to bounce anything off of anyone, I'm happy to do so.
For Clara, filing the request for judicial notice. So the statute has some requirements. It's not a specific number of days, but you do want to you want to file it in writing and serve it on the other party prior to the hearing. And it needs to be, in such a time that the other party could have received it and looked at it. Because if you some people think, and I think the statute, allows, you can wander into court and be like, here's a request for judicial notice, or I'm making an oral request for judicial notice. And you are allowed to do that. But the court is also allowed to say, no, you didn't put this in writing and serve it on the other side, giving them sufficient time to review and respond. So the best practice is to put it in writing, serve it on the other side. When I'm doing it, I do it along with my notice of representation, if I do an exhibit list and a supplemental declaration, I do it then.
And I would agree. I generally try and do it at least 2 days before the hearing. And the cases you can use on that last slide for the FVAP law website, that website is a full treasure trove of golden gloriousness. So if I use it all the time, and because I just can't keep all of this in my head. So go look at it. I'm going to check out the full litigation training after this, but from LAAC on it. But yes, FVAP is also my Shiro. They are an amazing organization, and they have been they did the Janesse versus Natalie case, and they have been more than generous with their time post issuance of the appellate ruling in helping guide us into how I'm going to handle the remand to the trial court on that. So
the work that they've done is genuinely incredible, and it has opened up a universe that was previously unavailable to low-income survivors of domestic violence. Like, if a survivor could not afford private counsel who is certified in appeals, they were not having success in getting relief from the appellate courts. That's why a huge amount of this case history begins in 2013 and 2014, because that's when FVAP gets off the ground and is raising up these cases that are just ripe for bad rulings, because there are survivors alone in a courtroom with a judicial officer who may be newly appointed to the bench and, coming from a corporate law background, has really just the kind of minimal X number of hours of judicial training on domestic violence. That is just a situation that is ripe for bad rulings that leave survivors unprotected. And without something like FVAP, there is very little recourse for people. So FVAP is incredible.
And in case you missed it in the chat, Minty points out that the Women's Law Association or Women Lawyers Association is putting on an appellate presentation to include Arati from FVAP in June. And Arati is, she's my paralegal calls her our best friend. She's an invaluable resource. So I'll be attending that, and I think you should too. And I think we're covered, right? Right,
Yeah,
Taylor?
I'd just like to reiterate in the what's been said in the chat, but LAAC will be looking into additional MCLE credit. And you all will know and get a message within a week with your certificate. But thank you both for sharing your expertise. It's invaluable and so wonderful. And the training itself is so full of fun, even with such a harsh topic. But thank you both again.
Thank you. It was a pleasure.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.